Thank you very much. And 30 minutes? 30 minutes. Okay. And that's going to be my topic today. That is how the information revolution is impacting on this specific field of the law, that is the laws of war. Here we have the outline of my presentation, so I hope to have enough time to present all these points. In a nutshell, two remarks on my level of analysis. First, I focus here on the topic of our workshop from a legal viewpoint, and moreover, such ethics of the cyber conflict are examined in connection with, as I told you before, today's legal framework on the laws of war and international humanitarian law. So the first aim is to sum up this traditional framework. In a way, this has already been done this morning, in accordance with the traditional distinction between jus ad bellum and jus belli, that is, causes and conditions of just war. A third possible scenario could be taken into account, that is, provisions for the aftermath of warfare, but I think that the traditional bifurcation is enough to understand what's going on in the legal field. So let me sum up this legal framework. Here you have the big picture. And in a way, what I will stress is how, a couple of things, how the very notion of force is changing, much as the role of sovereign states. So that let's start understanding the ways in which this traditional scenario, I mean this one, is changing. And first of all, some definitions. By referring to these new scenarios, I'm thinking of how the former U.S. counterterrorist chief, Richard Clarke, defines cyber war. That is, actions by a nation state to penetrate another nation's computers or networks for the purposes of causing damage or disruption. There are several other definitions, but just to have one clear notion of our subject matter. And, of course, such informational aggressions can be an instrument for real-world operations, traditional scenarios. For example, consider what the U.S. Secretary of Defense, Leon Panetta, suggested, that is to use computers so as to derail passenger trains, contaminate the water supply in major cities, and the like. Here, however, I will draw the attention to this traditional scenario, much as what I would call strict informational attacks. And in fact, we have to pay attention and take into account how the notion of force changes and how identifying the responsible party of such attacks can be tricky and even impossible at times. Let's start with the first point, that is the notion of force. For 2 millennia and more, taking into account Aristotle's remarks on just war, the law has dealt with the use of physical violence, but this is not necessarily so. That is, thinking about strict informational attacks, think about possible aggressions which aim to remove or annihilate informational resources or delete them without backup. That is, a warfare scenario without physical violence, but it's a warfare scenario. So that, here's the point. At what point does a cyber attack become an act of war? How can we define the threshold? And Well, what I suggest is to pay attention to our previous speaker. Here you have it. Luciano may be still having lunch. That is the view of information ethics, and especially the four moral laws that Luciano recalled after our break. Maybe you recall the last slide of the previous presentation concerning entropy and as that which not be caused in the infosphere and that which ought to be prevented in the infosphere and the like. From this viewpoint, well, we can widen our perspective and understand how the information revolution is affecting today's legal framework. In a way, since another presentation will be dealing with these moral laws, so first here to stress 3 points of this informational view. That is, how we can link traditional scenarios of the laws of war, physical violence, and the new scenarios of cyber attacks, informational attacks. First point, we can compare canonical targets of real-world operations on the battlefield with the new means of informational warfare, physical violence, informational attacks, because all the entities can properly be considered in terms of information. Second point, we can deepen at what point a strict cyber attack should be understood as an act of war in light of the amount of entropy that is caused by the aim to remove, annihilate, or delete such informational objects as the enemy's communication network or computers. In a way, since our societies are ICT driven or dependent, well, if your target is another nation's computer networks, well, you are targeting, following Luciano's metaphor, the heart of your enemy's society and system. Finally, we can clarify the scenarios of proportionality as a cause and condition of just war by relating the amount of entropy provoked by an informational attack to the amount of entropy which is either prevented or removed by such attack in the infosphere. So from this perspective, we have the convergence point between all scenarios, physical violence, and the new scenarios of cyber warfare. However, we have to widen the spectrum of the analysis since the information revolution impacts on the laws of wars also as a matter of procedure rather than substance, so as to define the authority that may properly enter the informational wars. As you know, for centuries, according to the Westphalian scenario, the only legitimate war declaring authority used to be the nation state. Since September 11, something changed, as you know. So let's deepen whether there is any crucial difference between old and new scenarios. In fact, the increasing dependence of today's societies on the information as a vital resource challenges the aim of sovereign states to monopolize the use of force in cyberspace as a new domain of military operations. In fact, not only authors of the new generation of informational attacks can be non-state actors, but, as I said before, identifying the responsible party of such attacks where non-state actors or traditional sovereign states is at times impossible. This difficulty of identifying the responsible party of a cyber attack affects the principle that wars need to be declared by the competent authorities. Moreover, it lowers the traditional barriers to entry into war, what Florida called the democratization of the war, since anonymity may trigger new temptations of exploitative attacks and shelter the anonymous informational offender from the reaction of others. So let me sum up this new scenario and examining it according to 4 different perspectives. Whereas the common ground is given by a nation state that identifies or submits evidence against the responsible party of a cyber attack. In a way, as I told you, there is this huge problem, identifying the responsible party. I'll return to this later. Let's assume, however, that identify this responsible party is possible. In this latter case, I propose you 4 scenarios. The first one, I presented as the constitutional one. That is, the responsible party of a cyber attack is a non-state actor, at least under sufficient evidence declared to be a non-state actor. And in response to such aggression, a national state intends to prosecute such actors according to its own criminal laws, and eventually in accordance with international law. For example, the Budapest Convention and the framework defined by this international European agreement. This is the first scenario, the constitutional scenario. The second one resembles the constitutional scenario with a crucial difference. Here, in response to an informational attack, the state conceives the non-state actor as a combatant enemy under the current laws of war, or even regardless of such rules, due to the evil nature of the aggression. Consider the very hypothesis of a non-state organization derailing passenger trains by penetrating a nation's computer network. May I call it the Bush Doctrine? Up to you. Third scenario. Here we are dealing with the international law field. Is a Hobbesian scenario in that an informational attack is carried out by a sovereign state and the target nation moves over the counterattack that may be appropriate in the absence of parameters and conditions which shall govern such cases of informational aggression. What to do? First option, which is given by the goodwill of the sovereign, that is, either for moral reasons or simple matters of convenience under the pressure of the public opinion. The state decides to constrain itself and abide by same, following Hobbes once again, the precept of general rule found out by reason, or why not, the four moral laws of information ethics mentioned above. Yet, in accordance with Hobbes' standpoint and the old Roman maxim, the wealth of the nation represents the supreme law, we should be prepared for the other way around, that is, no more, no less, a Hobbesian state of nature between sovereign states. In fact, in this latter case, it's up to the discretion and power of the state to determine forms and means of its response to a critical informational aggression. Final scenario is closely related to the previous one because it concerns the attempt to find out a feasible way out of the new international state of nature of the information era. And in fact, previous technological advancements have given rise to the drafting of international conventions and agreements over the past decades, so as to discipline and regulate the use of chemical, biological, and nuclear weapons, landmines, and the like. So, why not to expect something similar concerning the new scenarios of cyber warfare? However, there is a cautionary tale here, suggested by the field of military robotics technology. That is, 3 years ago, in his report to the UN General Assembly, Christoph Heinz urged that Secretary General Ban Ki-moon convene a group of experts in order to address the fundamental question of whether level 4 should be permitted to be fully automated. This is, so to speak, a legal loophole, lacuna, so that only an international agreement could govern this new field. Something similar for cyber attacks? Well, I'm not so optimistic for this reason. That is, since both the UN General Assembly and its Secretary General have been questioned up to this date, it's but a short step to suspect that a new international agreement on some critical aspects of informational warfare may take a long time. So, waiting for a new agreement in the long run, although in the long run, according to Keynes, we are all dead. What should we expect then? And this is my hypothesis. First, we have seen that even in the case of strict informational attacks, that is, as distinguished from informational attacks as a means for traditional real-world operations, some of these attacks seem to fall within the loopholes of current legal frameworks, and still some outlooks, for example, the four moral laws of information ethics, may allow us to conveniently approach many cases of informational warfare. So, my opinion is that the lack of an informational agreement doesn't entail a new Hobbesian state of nature in which all is permitted among sovereign states. On the contrary, we should wonder how about the international community may react to a devastating series of strict informational attacks that cannot be ascribed to a responsible party. There is the other side of the coin yet, because the increasing incapacity of national states to monopolize the use of force in cyberspace, which goes hand in hand with the difficulty and at times the impossibility of identifying the responsible parties of such informational attacks, suggests a national rather than an international legal threat. In fact, non-state actors will incrementally play a crucial role in cyberspace as the new domain of military operations, and several programs on online security and national defense have been developed in order to tackle the menace of this new generation of cyber attacks carried out by other sovereign states or non-state actors. And as some national programs have shown over the past months, I think about the PRINCE project, or since I'm living in London, the UK's GCHQ files, well, the endurance of Western democracies and the ramp to protect basic individual rights have already been tested by such international, national programs. So that my conclusion is that rather than a new Hobbesian state of nature in the international affairs of informational warfare, we should pay attention to a Hobbesian approach to matters of security and defense that may represent the main threat in the fields of national and constitutional law, since the new scenarios of informational warfare do not only concern the field of international law, after all. Short and ready for your question. Thank you very much.
Thank you very much, Ugo. Yes, Matt, please.
Thank you very much for your paper. Again, this is a sort of a question from ignorance, really. I'm a newcomer to this field. But it seemed to me that you slided halfway through the presentation from talking about cyber war to then information war and the ethics. And in fact, over the course of all the papers so far, there seems to be talk about cyber war and cyber ethics and information war, information ethics as well. And they don't strike me to be the same thing. I mean, when I think of cyber war, I'm thinking of Stuxnet and blowing up centrifuge and things like that, contaminating water supplies. Information war looks more like, as you yourself said, deleting information, replacing information, copying information. And they just seem like two different things to me. So I wondered whether I've just got that wrong or whether they are the same thing.
Let's say that cyber here is a species of a more general kind of paradigm which can be properly represented in terms of information. After all, if we represent all this stuff in digital terms, whether you're talking about cyber attacks or you're talking about informational warfare, most of the time think about the zeros and ones. But then we have to widen the perspective. So that's the reason why I started with very specific references to cyber attack and the definition by the former counterterrorism. Then to end up with a more general framework defined in terms of information. So back to your point, cyber attacks are not but a specific subfield of the more general framework defined in informational terms.
Sorry, so some cyber attacks, I assume, are adding information, aren't they, to a network?
I would say that all cyber attacks represent a form of informational warfare, but not all the kinds of informational warfare may be represented as a cyber attack.
Okay. Thank you very much. Any other question, comment? May I remind you, the gentleman will give you that your voices can be heard.
Thanks. Professor, I wonder about your use of warfare. I mean, to me, informational warfare, cyber warfare are but a subset of warfare.
Pardon?
Subset, or a species, as you said, of warfare. So they must share all the traits of warfare, namely violence, for one. Are you using the term in that sense, or more as a metaphor?
No metaphors permitted here. It's a serious stuff. So what's going on? It's a radical shift in our way of grasping the legal terms of this issue.
Okay.
In that, for two millennia and a half, the first great philosopher dealing with issues of just war theory was Aristotle, as I recall before. And from Aristotle till a few years ago, of course, when we were thinking about laws of war, violence and the like, we were thinking, for obvious reasons, about physical violence. What's happening, and this is the shift of the paradigm, is that we can still think about violence, but not as a matter of physical force. And in a way, if we deepen the philosophical meaning of what violence means, you will notice that we don't need any kind of physical coercion in order to go on speaking in terms of violence. But here's the point. Since from all the laws of wars were conceived thinking about violence as a physical, unilateral action, well, what's happening is that we have to start thinking about violence and take it seriously in terms of information. And here's again the point. That would be meaningless lest we understand that what's going on is that ours is an information-dependent society, so that it's vital to understand how an informational attack and informational violence is affecting the core of the system.
Okay, so we need to rethink the definition of violence itself, in your view? To adapt it, to expand it?
If you
because
think...
there is an ongoing debate on this. Very
Gentlemen, a quick rebuttal, and then we're over.
Okay.
So,
quick, no.
Great. Quick enough for me.
Not so quick. In philosophical terms, you don't need to redefine the notion of violence. In legal terms, yes.
In legal terms, yes.
Okay.
Thanks.
Anyone else? Any other question? Okay, so if you allow me, I will take the opportunity to ask a question. And would you please be so kind to go back to the very last slide? Yes, or one of with the OBS thing. So the question is very trivial, perhaps, but whenever someone points out at the OBS position or a business position, then to my mind comes like the other end. So if OBS is the old security guy, then there is Locke, which is the old liberty guys. So when you say that we are in a sort of Hobbesian stages of states against states, Are you also hinting at the idea that perhaps we might need to find a balance which needs to include also the Lockean side as the ideal which we want to reach, or as the other end of the spectrum, let's put it as well?
Wondering if you are mentioning Locke because both of you are coming from Oxford, but that's another point. Yes, Locke would be very useful in this context, at least to stress a key point. That is dealing with matters of security and the protection of fundamental rights or civil rights or human rights, take them as synonymous in this context. Locke is fruitful in order to recall, especially our lawmakers, that there is no legal room for a zero-sum game when dealing with the issues of security and the protection of fundamental rights. That is, since September 11, the trick has been, or the challenge has been, you want a security, forget about your privacy. Locke is fruitful here in order to recall, not only lawmakers, but scholars as well, that at least in Western legal systems, either you protect civil rights and then you try to balance matters of security with the protection of civil rights, and all the jurisprudence, say, of the European Court on Human Rights stress this point. Or if we are really lucky, we can aim to achieve a win-win scenario by protecting people's security and protecting their rights as well. So from this viewpoint, yes, Locke would be and is could represent alternative
So
point.
Oxford wins, just for the record.
Oxford 1, Malmesbury 0.
Yeah, okay, sounds good. If there are no any other questions, I think Anna Maria will present Ugo as well.
Thank you very much.
Thank you very much, Ugo, and hope you will join me.